talking about something much bigger than what we have. The support that given to the interpretation that you're studying is not relevant. We don't have any.
Do you think we should reignite the air condition? Ah, no, it's here. Sorry. Even I can reignite it, I think.
I think we need to turn up the volume of the mic
You think so? Yeah. Yeah. Yeah.
a little bit.
Yeah, that's good. Aha.
I don't think the source volume matters, but yeah.
Yeah. Thank you.
Ladies and gentlemen, thank you, ladies and gentlemen. Please take your seats. Thank you very much for returning more or less on time. We're doing pretty well. And whoops, caught some attention there. It's my pleasure to chair this next session of the symposium, in which we have three speakers who will be presenting to you. The first is Associate Professor Ludmila Stern, who I'm sure is well known to all of you, the First Lady on my right. The second is Professor Sandra Hale, who is the next lady along, both of them from the University of New South Wales and from the school to which reference has been made here. And the third speaker is not Alex. No. She's snuck in for a reprise, that's fine. You might get an opportunity to ask some more questions later on. But the third speaker is Mr. Stephen Dumit, who is a lawyer from the New South Wales Legal Aid Commission. And I should tell you that if interpreters and translators need to be engaged by the Legal Aid Commission, he is the man who makes the decisions. So he's the one you get at lunchtime.
I'll just say how much money I've got left in the wallet.
Each of the speakers will have 20 minutes, and I will make appropriate signals if we look as though we're going to run over that time. And then there'll be something like 25 minutes or so at the end for questions and for discussion. So it's my great pleasure to welcome first Associate Professor Ludmila Stern.
Thank you very much. Yes, I'll try to fit into the time allocated. The notion that court interpreting requires high level of competence, high level of interpreting quality, is something that we accept, that we take for granted. However, the question that I'd like to ask today is, what do courts do in order to contribute to the external factors that also impact on the quality of interpretation? And so in what I'm about to discuss, I will leave aside such aspects as education and training as preconditions of competent interpretation, and I will get stuck straight away into the external factors. Those of you who have first-hand experience of court interpreting will certainly relate to these factors, but I'm going to add to that, to the anecdotal and documented reports, also a bit of research that we hear that also contribute to our understanding how external factors can contribute to interpreting quality, or how they can subvert, how they can prevent interpreters from working in a professional environment where their needs are acknowledged and respected. And so there will be essentially three different areas that I will address. Our working conditions per se, physical conditions. It's the infrastructure to support interpreters' professional needs, preparation, quality control, and also the role of participants in the courtroom setting. I will be referring to court administrators, but also speakers and listeners, that is lawyers and judges. And so when we read academic literature that is based, that describes different court interpreting systems across the continents, and when we look at individual cases, high-profile cases where interpreters suddenly become the center of the spotlight and where their interpretation quality is challenged and questioned, such as these internationally known trials, and I won't focus on them, we hear the same points as being crucial in making or breaking the conditions under which interpreters can or cannot achieve interpretation quality. Again, you will recognize quite a few of them. So when you turn up to court, there is very seldom a preparation room where you can sit comfortably consulting reference or other materials. But worse still, when you find yourself in the courtroom, in the domestic court, of course, there is no dedicated place where interpreters can work comfortably, where they can connect their laptop or their portable equipment or anything else that they need for their professional performance. Now, all of that is, and I will get back in a minute to international courts, but so far I will also mention poor courtroom acoustics, essentially in the old style courts. The position of the speakers, we were talking about the sightline of interpreters in international courts, but again, you would have experienced speakers, lawyers, standing with their back to the interpreter, or rather the interpreter finding herself or himself facing the back of the speakers, the judges mumbling or not speaking into the microphone, and the lack of regular breaks, no water, no professional support. Other factors that negatively impact on interpreting quality have to do with professional needs. I mean, it's difficult to always separate purely physical needs from the professional needs. But I would only list the general absence of preparation opportunity, briefing materials. I won't elaborate on it because this is what Sandra is going to discuss in detail in her presentation following mine. No opportunities to consult reference materials in court, and in fact the ignorance of the fact that interpreters, like translators, have to consult reference materials. We already spoke during the previous discussion about the lack of interpreting team, whereby interpreters can take turns and can assist each other rather than compete with each other during interpretation. This way, if you are stuck for weeks in a dock next to the offender, there is nobody who will help you to take over from you in order to relieve your fatigue. And again, I will be talking a little bit later about the conditions in which whispered simultaneous interpreting, chuchotage, is not supported by either equipment or adequate delivery by speakers, again, because of the inadequate sound quality, background noise, voice strain, and so forth. The third group of factors already mentioned is a poor understanding by those who communicate via interpreters of the nature of interpreting process and what the interpreters need. Again, I'm beginning to repeat myself by highlighting the fast and unclear speech by the lawyers and judges, generally poorly structured speech, what we describe as unplanned speech, the speaker beginning to articulate a question or a statement and then backtracks because the question has not yet been shaped, planned in the speaker's mind. No briefing, no preparation materials. Now, this is not the only way courts operate, and international criminal courts, in a way, have written the interpreters into their practices as long ago as during the 1945-46 Nuremberg trials. It is interesting to note that it was an interpreter who was in charge of creating interpretation units during the Nuremberg tribunal, military trials. And in the same way, it was a practicing interpreter who was active in the setting up of the interpreters' services at the ICTY, the Yugoslav Tribunal, and Alex Tomic, who is here with us, already spoke about her role as a former interpreter in the creation of the interpreting section at the ICC. So there is a sense in international courts that interpreters belong there. Everybody relies on the services of interpreters. It is something that has been anticipated before the first trials even began. And the lessons learned from the Nuremberg Tribunal go as far as the Special Tribunal for Lebanon, obviously with the adjustment of conditions to specific cases, specific cultures, languages, and the times when the trials are being heard. And so the main features of what is considered by international courts and tribunals is that the interpreters are trained either beforehand in interpreting schools or in-house, that the remuneration is at a professional level, that simultaneous interpreters work in comfortable conditions in booths with adequate equipment, good acoustics, no voice strain, no external noises, and that the infrastructure is set up to support a high quality of interpreting. So the quality control and early error identification is built in the system rather than waiting for a crisis to arise, as was the case during the Australian war crimes prosecutions, where a crisis was necessary in order to start looking at the quality of interpreting and the conditions. Now, it is not true to say that all domestic courts across the world still follow the same, are still as backward in providing for interpreting needs. And we notice that when domestic courts have to deal with a high-profile trial of international resonance, suddenly resources are provided. Suddenly interpreting booths are being pulled out, and conference interpreters are being invited to interpret. Now, in domestic courts, there are also instances or good examples of good working conditions. In many cases, it has to do with interpreters being employed as part of the staff rather than freelance interpreters. And we have examples of the Singapore Supreme Court and USA Federal Court. In some domestic courts, interpreters do have a workplace. In some courts, even in Brisbane, the newly built Queen Elizabeth II Supreme and District Court, in theory, does have a pull-out desk for interpreters so that they do not have to sit in the dock with the offenders. We know that Auslan interpreters who work in courts are being engaged in teams of 2. And we also know that when audiovisual links are required, the courts are somewhat more considerate towards interpreters, possibly because it is new technology, and maybe because the consideration goes above all to witnesses who are located remotely or towards the jury. We have examples of isolated cases that have also been documented where the courts show themselves as enlightened, where preparation materials are provided, where 2 rather than 1 interpreter are being recruited for a longer trial. But I would say that this is still the exception rather than the rule. Again, to be absolutely fair, interpreter users do undergo a form of education, sometimes as part of their professional development, where they are given seminars and workshops about proper communication through interpreters and interpreters' needs. And we know that individual jurisdictions across Australia have also introduced various documents following the recommendations, for example, the recommendation of Sandra Hale's 2011 report about the protocol regarding the treatment of interpreters in courts. However, we also note that despite the goodwill, this process of improving working conditions in courts is still very slow. And our most recent observation in the past couple of years has shown that practices across Australia, across different levels of courts, remain very inconsistent, and interpreters are treated differently depending on where they happen to be. Different levels of NAATI accreditation are required by different courts. Training is not considered to be a prerequisite. Interpreters who interpret for the witness giving a testimony find themselves in different places. They might be sitting next to the witness inside the witness box, or else they might be standing outside looming over the sitting witness. Different instructions given by different judges about when to start and stop the interpretation. And whereas we believe that the defendant, the offender, is entitled to follow the course of his or her trial in his or her language, however, some judges believe that interpreters should not interpret legal deliberations. Why has it been so difficult? Why are these straightforward external factors, some of which actually do not require significant resources? Why have they been so slow to implement? There is no single answer to that. But again, what we have observed that, for example, the workstation for interpreters in the beautiful new Queen Elizabeth Court in Queensland, nobody seems to know that the interpreter's workstation is available. Nobody tends to be informing either the judge or the court officer that this little table can be wheeled in and out, and that there is portable equipment to take the interpreter out of the dock. So there still seems to be no protocol that would advise interpreter users as how to minimize the discomfort of interpreters' work. The worst, probably the most challenging of the subsettings of court interpreting is the interpreter who works in the dock. Because these interpreters are the least visible. Unlike interpreters for the witness, they have very little visibility, and they don't have the opportunity to attract the speaker's attention to their predicament. They cannot ask the speakers to slow down, to repeat, to clarify. They are the ones who get forgotten. And yet, when you think about it, a simple use of a more economical use of poor resources could have remedied this situation, rather than having, for example, one interpreter for each one of 4 or 5 co-accused who find themselves in the dock. All it would take would be to employ 2 interpreters who would alternate and would use portable equipment in order to interpret for all the accused in the dock simultaneously, and I would add, achieve the same quality and the same consistency in interpretation. So there are 2 major unresolved issues. One is that of remuneration, as we know only too well that interpreting is possibly, and translation, the only professions where the remuneration has not increased in the past few years, and in some instances has decreased. And as a result of that, there is no incentive to interpreters accept the fact that they are dedicated to their profession, but there is no a priori incentive to improve their competence through gaining professional education. And of course, in an age where everybody talks about the quality of interpreting, about accuracy, about the completeness, about the ability to manage the situation, this situation does tremendous damage to the profession by further deprofessionalizing it. Now, the second aspect, and that's I'm about to give the floor to Sandra, has to do with preparation materials. It seems to be such a straightforward provision to almost instantly improve the quality of interpretation. However, it seems to be a stumbling block, and whereby judges in principle seem to be sympathetic. Council on many occasions feel that if preparation materials have been given to interpreters in advance, it somehow is going to affect their impartiality and confidentiality. Somehow they are going to be biased and will interpret in a less neutral way than they would have done so otherwise. And so on this point I will stop and in a fairly smooth way give the floor to Sandra Hale. Thank you. I have your, oops, Sean, I think we need, unless you... It's, you are there, yeah. No, that's still me.
That's it. Okay, thank you, Ludmila, very much for your presentation. I will talk about a number of things, two main things, as you can see on the first slide. What does research tell us about the impact of education and preparation on quality of interpreting? So I'm trying to combine those two. So hopefully I will have time to cover those. So there are two major aspects to quality in interpreting. Ludmila already mentioned these two. So one is the competence of the interpreter himself or herself. So that is related to their background, to their education, training, professional development, as well as the level of bilingualism. So all of those things are, on the one hand, the interpreter's responsibility in inverted commas. We'll talk more about that later, maybe, if we have time. And the other aspect is, as Ludmila has mentioned, the working conditions that are afforded to that interpreter. So the best interpreter in the world will not be able to do a proper job without the adequate working conditions. So that's something that we need to always stress, because often interpreters are blamed for everything, and as Ludmila said, there are many other aspects surrounding the situation that are the major causes for the interpreter not being able to perform at their optimum level. And so we've got issues such as briefing, preparation materials, physical on-the-job conditions, and the behaviour of all the participants involved in the situation. Gian Bruno from Spain says that court interpreters must be properly trained, the difficulty and importance of the work fully recognised, the pivotal role in the judicial process acknowledged and accepted by judicial authorities, and the compensation established in accordance with their responsibilities. And she said this in 2008, and it's still very true. And I have to say that I am optimistic that things are improving, although they take a long time, but I have seen an improvement in the attitudes of especially judicial officers and in some of the things that they are doing in order to improve interpreters' conditions. So I'm hopeful, I'm optimistic, otherwise I wouldn't be here talking. I would have given up a long time ago. So the effect of education and training. So interpreting requires much more than bilingual competence. And this is something that needs to be reinforced, because again and again we hear of situations where bilinguals without any training whatsoever of any kind are assumed to be interpreters automatically. So this is the first stumbling block. Then once you have the level of bilingualism, which has to be very high, there needs to be an understanding of what accuracy means, of accuracy of interpreting. Because if you read the Code of Ethics and it tells you, okay, you have to be accurate, that can mean many different things according to the different settings, the different contexts, the different scopus or motivations and so forth. And so interpreters need to be educated on these issues to know how to interpret it in each of these different settings, because it will be different, as I said before. And Alex today mentioned one such example between conference interpreters and court interpreters, where conference interpreters are trained to summarise, improve, and omit some of the things that are seeming, or that are not that important in conference interpreting settings, such as hesitations and so on. Whereas in the court setting, all of those issues are very important. And so, although they are both accurate, they're accurate for the different purposes. So that's something that is crucial. Technical interpreting skills are obviously needed, and that is acquired through training and through practice. And in the legal settings, we need all of this extra knowledge of the setting and its goals and requirements, knowledge of discourse of the courtroom and of the investigative interviews, as was mentioned before, knowledge of the terminology and interpreter role and ethics. That's to mention the main ones. There have been numerous accounts of incompetent interpreting, and we read about this in newspaper articles, in journal articles and so on, and there are some examples here from the US and from the Refugee Review Tribunal, Migration Review Tribunal here and so forth. And as I said before, the blame seems to always go to the interpreters. And yes, at times the interpreters are to blame, but the system itself is allowing interpreters who are not properly trained, properly briefed, properly prepared to act in a situation where all those things are needed. And then when mistakes are made, which, as Alex said, we all make mistakes, that's a part of the job, but how to address those mistakes and how to overcome them and how to carry on with it is something that trained interpreters should know how to do. So when those mistakes arise, then the problem is no longer the court or the system, it's the interpreter's problem. Well, that cannot continue to be like that, because it will never change if that is the attitude taken. So examples of untrained interpreters' performance research from research results, I've listed some of them there. Arbitrary changes to question type, for example. So when we train interpreters in legal interpreting, we train them about the purposes for which each type of question is asked and how to how to interpret those accurately in the other language. Omission of discourse markers to preface lawyers' questions. That's another thing that trained interpreters learn. Omission of coercive tag questions during cross-examination. The purpose for cross-examination and why such things as tag questions, did you not, didn't you, and so forth at the end are used in cross-examination, and how that can be included in the interpretation. Changes to levels of politeness, how to address people in different languages. And culture obviously comes into play here. Changes of style and register in witness testimonies, which can lead to differences in the evaluations of the characters of those witnesses, which may change the jury's, if it's a jury case, the jury's perception and therefore the verdict at the end. Len Robert Smith, who was a Supreme Court judge from Western Australia, wrote an article which is the result of a presentation he gave at the Critical Link 5 conference, where he lists the number of poor interpretation leading to forensic error. And in this case, he uses forensic as in legal, not scientific. So the first one was no interpreter at all. So where the courts or the police do not hire interpreters because they think that they can make do without them. And that doesn't happen that much in Australia now, I think. I think we've overcome that first step. I think most legal settings require interpreters, and not only interpreters, but also most of them will require NAATI accreditation. So I think the first and the second ones probably somewhat overcome in Australia for the majority of cases, not for all of them. But the third one that he mentions is that even NAATI professional interpreters who don't have any legal interpreting specialisation, training, education, also cause issues because, as I said before, this is a very complex activity. It's not something that can be done by someone intuitively. It's something that requires very specialised education and training. So I think we need to understand that and recognise that before we can improve, before we can go up to the next level. So maybe we've reached that middle level, but we haven't reached the top level. Now, I'll move on to effects of lack of preparation on quality. The other one was concentrating on education. And this is a quote from a judicial officer, a magistrate or a judge or a tribunal member from the survey that I conducted on interpreter quality protocols and practices. And one of these judges or magistrates said, no preparation is required. They're simply translating literally what is said in court verbally. So this is, not all judges and magistrates believe this, let me say, but a lot of them do. Okay, I'm involved in training judges and magistrates and tribunal members regularly, about 3 or 4 times a year. And this is the first thing that I get from most of them, that translators, they think translators and interpreters are the same thing. Translators are there simply, and that's one thing I object to, simply or just to translate literally word for word. So this misunderstanding of what accuracy means. And what the interpreter needs to do in order to accurately render what the original utterance was. Diaz-Galas, on the other hand, so this is one, the first one was an attitude of people who don't understand what the work of the interpreter involves. And on this side, this is a researcher who's done some research on the effects of preparation on conference interpreters. And she starts by saying previous preparation is an important element of interpreter behaviour, both in interpreting training and in professional performance, with interpreters being trained and later required on ethical grounds to devote time to prepare for interpreting assignments. So it's taken as a given in the conference interpreting setting that interpreters need this preparation in order to interpret accurately. And she does a research study to show how much preparation can impact or can improve the performance. So preparation materials in international conference is a common practice. So you can see the AIC website where it states all this. It's also, as Ludmila and Alex said, common in international courts of justice, and briefing as well as materials to prepare all that will be interpreted or read on the day. So the interpreters are part of the team. The interpreters work with everybody else who's working in that case, in that situation, and they are availed of all the documents, all the information that is important, as Alex very aptly mentioned. So I won't talk about that too much. Now, some domestic courts also provide materials, some examples in the US, Wisconsin, for example. So it's not something that is only done in international context, but mostly in international context. Now, there is research that supports the need for preparation materials. It's not an issue of interpreters just being nosy or, wanting to know because they want to then tell their friends or they want to divulge what they learned in this very important case. I mean, ultimately, it doesn't really affect the interpreter whether they interpret it accurately or not. I mean, most of the time, nobody knows whether the interpreter interpreted accurately or not. They got paid, they left, okay. The good interpreters will feel really terrible. They know, well, I didn't do that very well because I didn't understand this or that. But, most people won't know. So it's the dedicated interpreters who want to dedicate more time and effort in order to do a proper job that care. And so it is the courts, the justice system that suffers if they don't provide the interpreters with these very important and basic tools. So research results have found that there are significant differences in interpreters' performance depending on whether they have had prior preparation or not. And the interpreting process, as you know, consists of the 3 major steps. So the first one, comprehension, then we convert it mentally, and then we actually deliver it. With regards to comprehension, there is quite a bit of research on monolingual comprehension of written and oral texts. And this research has found that prior knowledge of the subject matter, of the setting, of the topic knowledge and so on, domain and so forth, can have a major influence on listener and reader comprehension. So this is just monolingual situations. So we can then transfer that to monolingual. First, the interpreter needs to understand monolingually what the original says, and then they need to transfer that bilingually. And Diaz-Galas, in her research, her PhD research, found that 30-minute preparation prior to the interpreting task increased the level of accuracy significantly. So 30 minutes. And one of my recommendations in that report that Ludmila mentioned was that interpreters be paid about 30 minutes before they start the case so that they can at least go through the materials to be better prepared. Now, this study found that 84% of the interpreters, we had 138 interpreters, said they did not receive any preparation materials, despite guidelines that state they should. So there are some guidelines around for tribunals, for some of the general language policies that state that interpreters should be given briefing materials. So such as this Queensland Government one, brief interpreters on the nature of the assignment, providing relevant documents where appropriate. But it's not something that is generally accepted or well known or that is in all the regulations. Now, there were reasons given by the judicial officers because these two surveys that I conducted asked the same things of the interpreters and of the judicial officers. And the major point that they disagreed on was on the provision of briefing preparation materials beforehand. And these are the main reasons that the judges, magistrates, and I included tribunal members, gave for not allowing interpreters to have access to these materials. So the one was they didn't know, okay, so they didn't know why. And they considered that it wasn't their responsibility anyway. Maybe it was the court's administration responsibility, so, you know, they didn't know. The second one was that there was no mechanism for it. So, you know, how, when, who's going to pay for it, what is the way that they will receive the information and so on. The third one was a misunderstanding of the interpreting process. As I mentioned before, what do they need it for? All they need to do is listen, repeat in the other language. So a lot of them said that. The fourth one was simply inappropriate, unnecessary or undesirable, as Ludmila mentioned, because of the fifth one, impartiality and confidentiality issues. So this idea that the interpreter will divulge what they learn before the case, but once they get into the case, they're already there, and it's the same thing. So if they have to maintain confidentiality, it has to be throughout the whole situation. But having said this, I do admit that there are interpreters out there who are not professional interpreters, who are not ethical interpreters, who don't abide by any code, and who still get paid the same as the professional, well-trained ones, and they may do these sorts of things. There are unethical interpreters out there. There's no real regulation to stop that from happening. The sixth one is an interesting one, never requested. Okay, so this is where the interpreter's responsibility comes in. Okay, we need to be more proactive. Ask. Okay, and you'll be surprised how many times you'll be given when you ask. So, you know, if you don't have water, ask for water. They'll give it to you. If you want a seat, ask for it. They'll give you a seat. They can't deny that. You know, so interpreters need to be more forthcoming, more assertive. And the seventh one always comes up, cost. Okay, so I don't think it would cost too much, but it always comes up. Now, the reasons that the interpreters gave, on the other hand, for needing the background materials, one quote, everyone else in the courtroom knows what the case is about except me, and it can make my job so much easier if I had some context. And there's this sense of frustration from many of the answers from the interpreters that says, I am walking in here blind. You know, everyone is talking to everybody. Everybody knows what they're talking about. It's as if you go into a private conversation and you are supposed to be the voice for everybody and very accurate. You can't make a mistake. You can't, you know, not know something. But no one's told you what the conversation is about. Okay? So how are you supposed to do this? It's very, very difficult. To learn about the context and subject matter in order to better comprehend the case, to orient themselves if it is a part-heard matter, that's another issue. Someone else started before you and you just come in halfway through, to learn the specialised terminology. And I have many examples from my data of interpreted data that show that the reason why the interpreter is not accurate is because they didn't have the prior knowledge. It is easy to find evidence for this. General information about the subject provided to the agency or to the interpreter, documents that are going to be read out, relevant terms, a glossary, and briefing about the client. Now, a colleague of mine, some of you may know from if you did the CRC training that I conducted with Tony Foley, a lawyer. He's interested in helping interpreters achieve these things, and he wrote this paper which they're about to publish, so it's forthcoming, with a student of his, Dixon, where they suggest what types of materials can be offered to interpreters, because this is something that for which there is no agreement. So we had a symposium last year where we had court administrators and judges and magistrates and lawyers talking about this, and they couldn't agree on what the interpreters should have access to. And so this is what they suggest. A pre-trial briefing of interpreters should follow a protocol which incorporates these practices. So pre-engagement information, interpreters provided with the names of the parties, the type of the case, type of charge, type of appearance, expected length of presence required, the contact person on arrival, which is something that the interpreters in the survey also said, to be advised of requirement to produce evidence of the qualifications. It's important that they, for the record, they say what qualifications they have in case of appeals later, and provided with information on confidentiality so that they don't divulge any of this information. And then during or at each hearing level, interpreters provided with additional information. So at the first or subsequent mentions, copy of the charge sheet. After the plea of guilty, copy of the charge sheet, summary of police facts. If it's a defendant hearing, the list of witnesses, the charge sheets, expert evidence statements or affidavits, and jury trials, an agreed interpreter's bundle, which may include the indictment, names of witnesses, expert evidence statements, affidavits, précis of the opening addresses and so on. So these are minimum types of information that the interpreter could have access to in order to better prepare for the case. And obviously, and then sentencing and appeals, we can keep going. Obviously, this is more work for interpreters. And yes, there will be a cost involved because if we want the interpreter to do a professional job, they should be paid a professional fee. So I argue that there are many unrealistic expectations out there. Burke-Seligson, when discussing what they do in Ecuador with interpreters there, said that courts are happy to employ untrained bilinguals to act as interpreters at very little expense and then wonder why these poorly paid untrained individuals are not performing satisfactorily. And that is exactly what I believe too. So we need to have everybody working together to achieve the goal of quality. We can't just put all the responsibility on one party, which is normally the interpreters. Now, there's an issue of social justice here. When one person cannot understand... Oh, I finished my... Okay, I've got 2 slides. Can I go on? Have I got time? Okay. So it's not that interpreter or that person alone that suffers. It's the whole justice system. It's the whole case. So that's something that needs to be highlighted. A lawyer cannot do his or her job properly if the interpreter does not his or her job properly. The jury cannot do the job properly. The magistrate, the judge, they cannot decide adequately. So it's all a bit of a farce. Everybody thinks that everything is going well, but maybe nothing is going well, but it's all hidden because no one knows what's happening. So, conclusion, much has been said, but little has been done, although, as I said, I am optimistic things have improved. Many are quick to criticise, but few willing to advocate rigorous pre-service university training, provide adequate working conditions, and to pay professional rates. And there's a general lack of recognition of the complex nature of court interpreting as a highly specialised activity, so I think it's time to act. Thank you.
Is there a slide here for me? Is there one for me? That's it? Great.
Yeah, that's the one.
Yep, that's it.
Is it this
Do you
one?
want some water?
Fine. Yep.
Is it the
Just
Word-
scroll it up a bit.
Is it the Word document?
Yep.
Okay.
Yep, that's it. Great. No, I'm fine. Thank you. On behalf of the legal profession, I apologise. I'm the senior criminal lawyer in the Grants Division of Legal Aid New South Wales, and as Nick Cowdery said, I'm responsible for paying you when you're engaged for a legally aided criminal law matter, not for civil, not for family, but for a criminal law matter, and whether that's either by the in-house practice or whether by a private practitioner doing a legally aided matter. So most of you would have been down to the cells at Central with me or the cells at Parramatta early in the morning. not being paid overtime, so you have my sympathy. It'll be a criminal lawyer's perspective, and I don't apologise for that. It's what I'm familiar with and it's what I want to talk about. Just want to draw your attention to a couple of documents that I came across in preparing the talk I'm going to give today. The Community Relations Commission prepared a legal glossary for interpreters. It's on their website, it's available to you, and it's really helpful. It explains terminology that lawyers and judges use. When we talk about my friend, we're talking about the lawyer at the other end of the bar table. When we're talking about my learned friend, we're talking about the fool at the other end of the bar table. And I'm yet to have anyone explain to me why we lawyers always use the word cavil. Don't want to cavil with Your Honour. It means, as my 14-year-old son would say, don't diss with me. So it's don't argue with me. So if anyone can say to a judge or a magistrate, forget the cavilling, let's just disagree. Okay. And we lawyers, we're the only ones who talk about intoxicating liquor. We're the only ones who always refer to a car as a motor vehicle. You know, we're verbose. We can't help ourselves. One of the things I look for in an interpreter is accuracy. I don't apologise for that. I have had Arabic interpreters for Arabic-speaking clients. And the client will say to me, I don't understand what they're saying to me. He's from Egypt. And the client will be from Lebanon. And they say, I can't understand what he's saying. Or I will have ostensibly a Chinese interpreter and the client will speak Hokkien. And it's very difficult to find someone who is completely fluent in Hokkien. I know that interpreters don't interpret verbatim, but sometimes it's important that the exact words that have been used must be interpreted. I know that creates problems, particularly, say, with an Auslan interpreter who has to unpack the words and put it into a language that can be understood by the deaf person. And that deaf person's answer to the question may be shown by way of a shake of the head, and then the answer that's interpreted back is in the affirmative. Okay? So I understand that, but there are a lot of judges and lawyers who don't understand that, and who don't understand that, no, I don't agree with that, but my answer is yes, is in fact a correct interpretation. It's not verbatim, but it's a correct interpretation. I know that sometimes there just isn't even a word for it. Okay? It might be, it happens sometimes in criminal matters, probably happens more in, say, personal injury matters and talking about medical terms and things like that in parts of the body. And, you know, the general term might be the arm, but, you know, you might be talking about bones in the arm and there's no word in the particular language for the bones in the, or the particular bones in the arm. It's just the arm. Okay? And I accept that. But there will be some judges and lawyers who don't understand that. So you've got to be aware of that. You have to be able to interpret the distasteful, the vulgar and the offensive. You can't be shy. Okay? We need to know what is said, because sometimes it's really important, particularly in a criminal matter where provocation is important in the case. And we need to know just how offensive those words may have been. Okay, I talk about, these two topics aren't on the top two, but they're on the top of the screen. Speed and overlapping. Okay, in a conference, there's no issue. You have all the time in the world and you interpret at a good speed. When I am cross-examining the other party's witness, I want to bear down on them. I don't want them to have time to think. I want them on the hop, and I don't want the interpreter to slow it down. Okay? And that's a tactical thing. When it is my witness who's being pummeled in cross-examination, I do want the interpreter to slow it down. Okay? So, different perspectives, okay? But when I want to nail the witness, I don't want it slowed down, okay? So you've got to understand that there's a tension there. Okay, what is not obvious? Eye contact. I know when children don't look at me, or sometimes when Aboriginal people don't look at me, they're still listening to what I'm saying, but it might be a respect thing. It might be something that's fear. When it's a foreign language that's being interpreted, I need to know, is it a cultural thing or is it something more? Is it educational intimidation? You as interpreters are educated. Quite possibly the poor person you're interpreting for has never been to school. If you're the person who's there on a Saturday or Sunday morning interpreting for the poor drug mules who've come in by plane the night before, and you've had them at the AFP headquarters and those poor people have possibly never been to school, never had any education. So I need to know, are they not looking at me because they're exhausted? Are they not looking at me because, the yes doctor effect? Okay? You're the educated one and they will just only look up and, nod yes. I need to know things like that as a good criminal lawyer. I need to know, and sometimes it's difficult for you to tell me as well, because it's difficult for us to pick it up even when the person speaks English. I need to know, is there mental illness or intellectual disability or organic brain damage brought about from, say, excess alcohol consumption or an acquired head injury? So they've been in an accident and, a bit slow as a result of that. Those things aren't obvious. As I say, they're not even obvious if the person speaks English. They may be animated simply because they might be animated people, but they might be on speed. Tiredness might be mistaken for depression. I had the experience of representing a lovely man. He was a lovely deaf man who lived in the inner city area of Sydney. And what he liked doing was feeding the birds, feeding pigeons. The neighbours didn't like him doing it, and he used to react. And he had very little Auslan, very little communication skills at all. The neighbours didn't like him doing it. He would react. The neighbours took out an apprehended violence order against him, personal violence order. The Auslan interpreters may know this fellow, Peter Bonser, who is probably one of the best deaf Auslan interpreters in Australia. And I was fortunate to have Peter as the interpreter. And Peter said to me, this man, in effect, has no language. He has an intellectual disability or mental illness. He wasn't sure. And he said he's never really been to school, whether that was, a school for deaf children or whatever. He said he's in effect got no language. He doesn't have Auslan. He doesn't have English. Why that created a big problem is that when an apprehended personal violence or domestic violence order is taken out, under a section of the relevant act, it says, insofar as it is reasonably practicable to do so, an explanation is to be given in a language that is likely to be readily understood by the person being given the explanation. had to say to the magistrate, you can't be convinced that this man even understands what we're saying. Even though there's an interpreter here, he has no language. The consequence for that poor man, if the order was made, was that if he breached it, and if he breached it with violence, he gets locked up. And when the poor fella doesn't have any language anyway, try explaining that to the police at 11 o'clock on a Saturday night when they've got all these other blues going on. Okay? So if you have that insight about the client you're interpreting for, let us know. Conflict, compromise and bias. There will be cultural and political issues that attach to the interpreting job you're involved in. It may be the fact that you're a male interpreter having to interpret for a female victim. It may be that you're a female interpreter having to interpret for a male accused, particularly in a sexual assault matter. Very difficult. It might be a religious problem. It might be a Christian interpreter and a Muslim client, or vice versa. It might be a Sunni Muslim and a Shiite Muslim. The great difficulty there. It may be a caste system issue. Okay, as I said earlier, the doctor effect. The fact that this person, the interpreter, is the educated one and the client is not the interpreter, not the educated one. The whole issue of asylum seekers and refugees. They don't know who they can trust. Okay? If they're from an emerging language community, or, what I mean is like a community with a very small number of interpreters, they have no idea if you're trustworthy. I've had an interpreter say to me, and please don't take any offence, an interpreter, a very, very educated man from South Vietnam, who interpreted for a man who was from North Vietnam. And at the end of it he said, look, I've interpreted what he said, but you can't trust a word those North Vietnamese say. Okay, so his own, from 20, 30 years before, his own experiences still came to the fore. How small is the interpreting pool? That's a big problem. Okay, especially, as I say, in those emerging communities. Have you had a prior involvement with this particular client? As I said to you, if you're the one who's got called up to attend at Goulburn Street, Australian Federal Police Headquarters, where the questioning starts as soon as they're off the plane, and as far as the client's concerned, you're part of the system. You're part of the police. Just as they often think legal aid are part of the system. And legal aid lawyers, you're not the real thing because I'm not paying for you. So what do they call us? The Pepsi lawyers, because only Coca-Cola's the real thing. So we're the Pepsi lawyers and we're part of the system and we're selling them down the river. And you interpreters, if you were there at the ERISP and you interpreted the ERISP, okay, you're part of the police as well. And for people who come from, a more totalitarian system than what we've got here in Australia, you're as much on the back foot as the legal aid lawyer. Okay? They may not tell you the truth. The interesting thing about the preparation, a concern that the client may have is if you know about their case before court starts, that will add to the conspiracy theory. Okay? It may eventually over time be able to be ameliorated, But if you've got a client who doesn't know who they can trust, and the interpreter knows all about their case before they go into court, that will feed the conspiracy theory. The whole confidentiality issue. Okay, again, if it's a small community and you're having to interpret, you know, when people are arrested, they're at their lowest and they're at their most vulnerable. And if they know who you are and you know who they are, they need to know, look, this is the interpreter. Their job is only to interpret what goes on in this cell or in this courtroom. They are not going to talk about it outside this cell or this courtroom. And I always say that to the clients, and I know it's always interpreted to the clients, and I hope it works. Okay? We've got to build that trust. Can I talk about one instance where no interpreter could have helped at all? I had a client whose father was Scottish from the Gorbals part of Glasgow. Apparently there are YouTube clips of people from the Gorbals part of Glasgow because they are so unintelligible. It was all about a goods in custody, and Dad said, the son said, look, the electrical goods, they're all Dad's, you know, they weren't mine, they were Dad's, and Dad will come along to court and say so. I made the mistake of not proofing Dad or getting evidence from Dad or speaking to Dad about his evidence before he went into court. I just got his name and his address and, you know, these things that you say, you know, the police say are your sons, they're really yours, aren't they? He said, aye. And so I put him in the witness box and asked him his name and gave his name with this broad Gorbal accent. And I asked him his address, and I think it matched up to where his son lived. I wasn't sure. And at that point I was ready to ask for an interpreter. But then I asked him, what do you say about these goods that the police say are your sons? It was like Billy Connolly on speed. He spoke for about 5 minutes. I didn't understand a word. I sat down and said, that's the evidence. And the prosecutor stood up and said, no questions. And the judge, the magistrate at the said, oh, well, you know, I find, you know, the defence is made out on the balance of probabilities on the evidence that I've heard. And I'm sure he spoke English, but not as we know it. So they're the things I wanted to say, and I think we've left time now for questions. Okay.
Well, thank you very much to the speakers. They've each introduced a number of issues that I'm sure will be controversial. And this is the time for questions, comments. Please just briefly identify yourself, and if you have a question for one of the speakers in particular, could you identify that speaker so that he or she can start thinking? There's a hand up here, there's another one there, they're all over the place. I thought that would happen. So let's go. Your turn.
Can you hear me now? Yes. Thank you. A question for comment, perhaps for Stephen Jimmy, please. As an interpreter who works with courts and police and legal aid sometimes, I have to say that I don't see my role as stepping in to advise the let's say the member of the judiciary I'm working for about cultural issues or mental issues. I really see myself there as facilitating communication between people who don't speak the same language. I am not trained to pass comments about the mental health people. If I did pass a comment, I may be totally wrong, even if I spoke and thought sincerely what I said was correct. And I would see this something fairly dangerous to do. I may give incorrect information and perhaps change the course of the interview or something like that. I may contemplate answering questions if they deal with the actual language. For instance, I was asked once by a policeman whether the person they were interviewing was drunk and slurring their words. Well, that's sort of a borderline one about slurring your words. I think I did answer that question. But beyond that, I think it would be very dangerous for interpreters to pass comments on areas they're really not qualified to talk about.
Yeah, Francoise, thank you. That's an intelligent way of it's an intelligent way of thinking of it. I suppose it's just if there is something obvious and it's something that the lawyer isn't picking up, because there may be issues and we may go off, half-cocked without any idea that actually, this person should be getting a psychiatric report and at this point in time. Because if they are mentally unwell at the instance that of arrest, and that arrest is proximate to when the offence occurred, there may be a mental illness defence available to them. So I'm not saying you have to be, a pop psychologist or pop psychiatrist or whatever and give a diagnosis, but you can sometimes assist us and say, look, there may be some other issues going on here besides just what they're charged with. And if we're wrong, that's fine. We'll go get a psych report, a psychiatric or psychological report, and it'll say yes or no. It'd be so much better if we could err on the side of caution and the answer be yes, rather than, we get 2-3 months down the track and we find out they're in the psych annex at Long Bay or they're actually in the hospital at Long Bay, and we've missed this opportunity to get a very important report at the time of arrest. Okay?
Not convinced.
No.
Yeah, okay.
Yep.
Mm-hmm. I think that you don't want to err on the side of caution. You want to err on the side of caution. But
I can't hear you. Speak right in the microphone.
Oh.
Is
So
it
this-
on?
Yes,
Yes. So the interpreter doesn't want to err either. The interpreter doesn't want to say something that if it becomes apparent, it'll become apparent. The interpreter is there to, indeed.
Can't hear. Still closer to your
Is it
mouth.
close?
Like you're singing a song.
Yeah.
Oh, okay.
Closer.
Okay. Then close.
That's it.
Oh,
Yeah,
that's close.
Yeah, clearly never did karaoke. All right. So an interpreter cannot give an opinion on what they are not supposed to give an opinion on. They are you want them to do two things. You don't want them to know things, but they should know things. Sorry if I'm being a little bit harsh. You don't want them to know things beforehand because somebody will believe in a conspiracy. But if they talk about what they think, and interpreters think all the time, they take it all in. They come into the world of the court or the police interview or the prison, and they will pick up on a lot of things. When you're trained and you work as an interpreter, you enter a room, you instinctively know where the power is. You instinctively know who is subdued, who is feeling authoritative, what is the situation, is somebody feeling ill. You notice these things, but you are not going to give an analysis report to anybody because it's not your job. Your job is to be prepared, to do what you can, and if you don't understand something, you will ask. Now, if an illness is going to be picked up, it will be picked up. What the interpreters must not do is that they mustn't do anything that will prevent the communication. what we teach our interpreters, especially I'm talking about field interpreters because this is more like community interpreting, don't do anything that will make the interview fail because of you. So you shouldn't be the reason why something fails. But if the interview or the hearing or anything fails for other reasons, you can't be the miracle that resuscitates it. You can't make it happen.
I agree with everything that Alex has said, but I think I want to try to defend Stephen. I think I understand what he means, but this is how we approach it from a trained interpreter's point of view. As Alex said, and Françoise, the interpreter cannot give a psychiatric opinion, and you agreed with that as well. The interpreter's role is to try and remove that language barrier and to try to achieve the effect that the original would have achieved in someone who understood that language in the other language. So I understand your point from that point of view. So what you're saying is, if you had understood that language, you would have understood that this person is really not speaking in a manner that a person who is with the full capacity would speak. Okay. The interpreter will understand that. The interpreter needs to try to achieve that when interpreting. So if the interpreter interprets in the same incoherent, hesitant, unresponsive way, so that's what an accurate rendition would be. It doesn't mean word for word, but it means in that same tone and that same manner, then you will be able to pick up on that cue. So what I tell judges normally is, instead of thinking the interpreter's not interpreting accurately here, we'll blame the interpreter for this, or something sounds odd, it must be the interpreter's not interpreting accurately. Maybe, but if it's a good interpreter, it means that the interpreter is being faithful. So ask the questions of the person, whether it's a cross-cultural issue. Is there any reason why you're saying this? In your country, do you do this or that? So that it removes the burden from the interpreter. Or did you not understand my question? And then if they come up with something that's completely irrelevant, then that will lead you to think, okay, there must be something else here. It's not just or don't you understand the interpreter? Maybe it's a dialectal difference. So it's bringing the responsibility onto the lawyer, in this case, if you're the interviewer or the police or whoever it is, to try and figure out what's wrong, rather than expecting the interpreter to go beyond the role and to offer extra explanation.
One up
At the back.
I'm Portuguese interpreter. My name is Ana Joana. Can you hear me?
Yeah.
Can you hear me now?
Yes.
I've been in the profession for many, many years. And when I worked with the health system in New South Wales, and when we first started, we took a short course in psychiatric interpreting. And that gave us a very good knowledge of how to not try to make sense of the answers we get from the person we are interpreting for. It's very tempting for an interpreter in a court situation or in a legal situation to try to, when you render into the other language, to say something that makes sense. But it's very wrong to do that, because in most cases there is doubt about the level of intelligence or mental health of the person. If you try to make sense of it, you're not going to present that person as it is. So you really have to be very careful never to do that. If the person is not making sense or gives the wrong answer, that's the answer you have to give. Not try to make sense of it.
Great.
Yep. We'll take that as a comment, and a very good one. Yeah. One question down here, and well, up the back first, and then you respond.
My question was the same as the ladies.
Right, no, behind you there's another hand up too, so we'll get there.
I think you can hear me if I speak without the microphone.
We have some remote listeners as well, so the microphone is important. Unless you can shout all the way to Western Australia.
Good morning. It's not a question, it's an interesting thing that out of interest. Thank you very much for everyone, but I'd like to ask, what happened with the court case with that man? Was he convicted, was he acquitted, or was it just
He was acquitted. Yes, justice was done. He was guilty, but he was acquitted.
Hello, my name is Gordana Valsika. I'm the manager of the Healthcare Interpreter Service in Western Sydney. My entire experience has been in health, so I really enjoy the session, the morning session. This is entirely new experience for me, and I appreciate the enormous amount of challenges that you are facing, everyone involved in court system is facing, from interpreters to the judges. My question is actually about probably an additional challenge that hasn't been mentioned here. We do provide debriefing to our interpreters in the health system, so I wonder if there is any provision made for debriefing, and obviously with all these challenges mentioned, I doubt there is. And I would also like to know if there is such system in place in Australia, and particularly in the International Court for the former Yugoslavia. I would be interested to know from you, Alex, how did you, or whether you had any provision for debriefing for people who were working as interpreters in the court and who actually were survivors of torture or trauma in former Yugoslavia. Thank you.
Thank you for your question. This is something that I did not mention during the presentation, simply there was not enough time. But we did, I think to begin with, there was very little sense of what we are going to find, because in 94, 95, when it all started, it was just emerging, and all the statements were coming in and so on. So I think we found out as we went along how awful it really was, and I think the International Criminal Tribunal for Rwanda had an even harder time. And although it's very difficult to discuss the degrees of horror, I think in that sense, I think Rwanda unfortunately has that sort of higher degree. And what we did is that we at the ICTY, I think we realized fairly late that we had all suffered traumatization. And I think that it was through being able to talk to each other, so debriefing each other was helpful. There is a difference between translation and interpretation in that sense, where the translators would be the first ones to go over something in writing, and then the interpreters would read the text and then have to interpret in court. In both cases, I think there is a question of secondary traumatization, but that would also be valid for the lawyers, for the investigators, for the court reporters. And it was very important to get the sense of awareness to recognize if somebody is traumatized. And there is the UN provided us with some guides on how to recognize, I think they just called it stress, and that sort of covers a whole load of things. But yes, a lot of us did go through it, and it is very difficult. I think the main thing, and this also to do with crime, and that's why courts are such tense places, is that it takes away all illusion that the world is a good place, and basically that challenges your values. And all of us reading any awful thing that happens, all of us think, what would I do? And interpreters have the added difficulty that they will be speaking in the first person. So they will say what happened to the person, but they will be speaking about, well, not themselves, but they're playing the role, they're the voiceover. And I think that's quite difficult. In the ICC, we did provide for we call it self-care or self-help. And this is about recognizing the signs. We have greatly involved with the staff welfare officer. We've had several over the years. I don't think anybody can stay for very long. But essentially, this is about resilience. This is about resilience training. And it's also very important that when people are recruited to work at the court, unless they work in finance or not even human resources, I think is bad. But it's not for everybody. Just because you can, unless you can go to court every day and talk and speak it and write it and talk about it, and then still go home and be able to relax and to de-stress, to have to realize that you shouldn't maybe go straight for the drinks cabinet, that's not a good thing, and that's something that we've been told repeatedly. Or for any other form of relaxation, which would be really very temporary. I think that is helpful, but acknowledging it is very important.
Any other comments from the panel? No?
Maybe that there is no
Maybe there are occasions when drinks cabinet is quite useful. The gentleman here and then the lady there. This question of debriefing and mentoring and so forth, as Alex has said, it affects everybody who's involved in the process. And it's certainly an issue for prosecutors, I can tell you, when they are exposed to the same sort of criminal conduct, particularly gruesome kinds, for long periods of time. Violence, child sexual assault, which is a very common offence tried in our courts. Continuing exposure to any of these underbellies of the community have to be addressed in a proper and responsible way. And debriefing and mentoring can help enormously, and I'm sure it can with interpreters as well. Yes, sir.
Hello, I'm John. I'm a student from Pichon TAFE, Advanced Diploma of Interpreting. By my speaking, you may know I'm just a student. I'm not so very proficient in English. But I will ask in terms of the conspiracy thing, I just want to know, because when you're doing the prosecution, if you're on the defendant side, the lawyer or somebody, they have already got some material for the defendant to read, or the lawyer would have some documentation for all these things. So if I could get input beforehand, before the court hearing, I might be able to prepare pretty good. Not as 100% well prepared, but at least I have 50% or have other experience or some other terminology I would be able to get from other resources. So in this case, my interpretation will be much better than I just go there without anything in hand and just go into the courtroom, just like something come down and a bombardment on my brain, and just I have brainstorming and just, I think for the whole first session I will total lost. And then for if I have some preparation or I have some terminologies or something beforehand, just not attained or not just tuned to this hearing, I might, if I'm good enough, I might be able to pick up soon. Otherwise, the whole thing for the first part, I think, just waste our time. So I don't know. I think the rules is made for people to carry the job accurately or more smoothly, rather than the rules have to stop people from doing the right thing, right? So I think there will be something. In this case, the created this issue be raised up, I think there should be something to develop some regulations and rules towards this question, because it's very controversial. Thank you. I'm not very good at English.
No, it's good.
Thank you.
Sandra.
Well, he's passed it on to me.
Well, as Sandra has said, there are guidelines already being developed, and they're not rules yet, but there are guidelines, and some judicial officers are giving thought to them. Look, I agree with them in theory. I can see practical problems with it, particularly issues, say, where there's a lot of evidence, and if you're providing if the lawyer is providing the interpreter with the whole brief, they may have to invest days in reading the evidence, and you'll have telephone intercepts and listening devices and surveillance, and you might start reading the transcript, which has been transcribed by another interpreter from the foreign language into English, and you might start reading it and saying, I don't agree with that. And you will. And you know, I have a number of cases where the interpreter who's been engaged for the defence looks at what the police interpreter has transcribed and says, that's not right. And all of a sudden we're having to reinterpret or have retranslated, you know, hundreds of hours of telephone intercepts. Or the court has to listen to them all and have them interpreted, and you'll have, you know, the different interpreters say, that's not right, or my interpretation of that's different. Okay? So I agree with it in theory. I see some problems in practice. And it'd be good if guidelines can be developed and everyone can agree on them.
I don't think anybody's asking for a whole brief when it's a very complex case. But if you have had a good regulations in the first place, then you wouldn't have had the wrong interpretation or translation of the very first case file. You agree with me? I think I have to say something here about community interpretation, and that involves also the medical professionals who need interpretation. In international conferences, and I'm not talking about international courts, I'm talking about conferences, ministerial conferences. Look at the prime ministers, presidents. When they go abroad, they get prepped. They are given briefings on the protocol, who sits there, who sits where, which fork they will use, how they will walk in. I was told many years ago by a very distinguished interpreter, never walk on the right-hand side of the minister or the prosecutor you're interpreting for, because they might think you're his wife. So that's one thing you're told when you're working on high levels. And I have to say, I always hated high levels because you have to remember so many titles. And you are told those titles. You're told who's the highness, who's this, who's that. You have to remember it all. You have to prep. And it's very hard. Now, these interpreters, they're never just one. You always have at least two, even for a 10-minute meet and greet between a US president and a French president. There will always be one who will be the net or who will be for the other side. So why is that? Why is it that so many, and those meetings are a lot less substantial than a court interpretation, than a person who's in detention, or a patient who really needs to communicate with the doctor? And while I am aware that, although I come from a country that used to be socialist, and this will sound very Marxist, but it is to do with social justice, is that, and I apologize if this is very political, the rich and the powerful will have very well-paid, trained, prepared interpreters. And the rest of us, well, let's hope for the best. Because that's what it comes down to on a very global level, that in very few countries, if you're a witness and let's say you need interpretation in Sweden, you will get a perfect interpreter who will know your language and they will be fine. But let that not happen to you in Serbia? Because you can get maybe a great person, you get somebody who will have no clue. So that's the difference. That's the difference, and not to say nothing of other countries. But I do believe there is a difference. We make that difference, and that difference is in the payment. It is in the payment, is in the qualifications, is the level of accreditation.
On that note, I'm afraid I'm under strict instructions to bring the session to a close, otherwise there'll be a mutiny if we keep doing much. It seems to me, as an observer, that one of the things that needs to happen is much better organisation on your part, so far as standards and professional training and representations to the authorities are concerned, and I hope that you are very successful in doing that. So would you please join me in thanking our panel, and it's now lunchtime.
Should I say about
Just before you leave, to remind you that we expect you here in an hour's time, so at about 1:50. There is a number of food outlets across the university campus. You may have seen some of them. There are cafes, there is more of a fast food type place. If you walk past the library lawn, there is a sort of an arcade, which is a food court with different types of food. So hopefully you will have enough time to eat. Anything else? We'll see you then at about 1:50 p.m.
No, but I do feel very strong.
Me too. I've said that many times.
I really,
because
you look at the silly meetings they have with the presidents. You know that nuclear security summit that they had in the I don't know, 60, 70 presidents, heads of state, they all came together. They had interpreters from all over the place. They had this amazing. The security alone cost 23 million.
I've often said that, in conference interpreting, it's more of a show, because most people will understand, unfortunately.
Well, they do it in the EU, of course.
Yes.
Then it's different.